New protections for temporary workers in Australia. Understanding the Migration Amendment Act 2024. A breath of relief for Australia's temporary workers, as Australia has recently introduced legislation to protect their work rights. Watch our complete video to know the details. Want to know your chances of immigrating to Australia? Click the link in the description below to access our free Australian visa immigration points calculator and take the first step towards your dream. Now back to today's video. The Australian government has recently approved the Migration Amendment Act 2024, which imposes stricter penalties on employers exploiting temporary workers. This will be effective on July 1, 2024. Basically, this regulation focuses on protecting temporary workers while discouraging employers from pressuring these workers to breach their work-related visa conditions. If we take a closer look, in the Migration Act 1958 and Migration Regulations 1994, the work rights for temporary visa holders are specified, including limitations on work type, employment tenure with any one employer, and the work frequency. However, the Act also describes that working in Australia without a visa, or as an unlawful non-citizen, is an offence. What's interesting is that the penalties for employers breaching these legislations are notably raised, with some fines even quadrupling. This legislation also introduces new offences and civil penalties for work-related arrangements that go beyond usual employment. So, these include actions such as accepting unsafe housing arrangements and surrendering a passport. These rules are intended to stop employers from pressuring or coercing non-citizens into making decisions that might compromise their immigration status or violate the terms of their visas. Furthermore, the Act launched a migrant worker sanction, focusing on employers who have violated specific provisions of the Fair Work Act 2009, or employers who have been guilty of work-related offences under the Migration Act. If an employer is subject to such sanctions, they could be deemed prohibited employers, which means that hiring more non-citizens would be illegal. While some sanctions may result in a prohibition of up to 5 or 10 years, the most severe penalties, which are related to human trafficking and slavery, have no maximum prohibition period. This legislative update highlights the commitment of the Australian government to eliminate temporary workers' exploitation while ensuring employers obey immigration and labour laws. So, what's the takeaway? Employers must be vigilant and informed regarding their obligations under Australian immigration law. That's a wrap for today's video. If you want to stay updated with our latest uploads and exclusive content, make sure to subscribe and ring the bell. Thanks for being a part of our community.